Good afternoon, everybody. Welcome to today's webinar hosted by Osborne, Clarke and Giant about all things Belgium. Just bear with us for a few seconds. We're going to wait whilst people enter the room. We've got quite a number of people registered currently coming in. For those who are already with us, do familiarise yourself with the toolbar at the top of your screen. You have an opportunity within the chat section to say hello, introduce yourself, let us know whereabouts you are in the country. And also from for questions and answers, there's a Q&A button at the top there. So once we've gone through the set questions that we're going to cover today, there should be a good opportunity to answer any specific questions that you have. So please do pop them in the Q&A. And we'll cover those as we get to the end of the session. It looks like the numbers joining are starting to slow up, so I think we're in a good position to get going. So welcome everybody to this webinar today, looking at the compliance and legal considerations that businesses should be aware of when hiring workers in Belgium. I plan to spend about 45 minutes covering off all the sort of main considerations you should think about when you're looking at engaging contract or contingent workers in Belgium. I think no matter where you operate, whether that's in the UK, Belgium, or further afield, we all recognise that there are shortages of talent available across many countries and different industry sectors. And so hopefully today we want to explore how you can access talent pools within Belgium, but making sure that you stay compliant with the local legal considerations there. So what we've done is set a few common topics that we can work through, and I'll pose some set questions to our guests today that will weave us through those areas. Firstly, we'll start with the Belgium approach to leasing temporary workers. Specifically what the licensing requirements are for employer of record companies who employ and operate within Belgium. We'll then look at how the Belgian authorities approach that thorny old topic of worker misclassification, which is also always super interesting. We'll talk a little bit about the EU Platform Directive. Charles will talk through the available contract engagement solutions, so the options that you have if you wish to outsource engaging workers in Belgium. We'll also, towards the end, then look at, from a UK agency perspective, what requirements you need to think about if you're thinking about setting up operations in Belgium. And then, as always, we'll finish off with Q&A from the questions that you've been submitted. So please do pop them into the Q&A section, and I'll try and leave 15 minutes or so at the end of the session to cover those off. So today's webinar is brought to you by Giant Group. We're a leading contingent workforce management company for over 30 years and delighted to partner with Osborne Clarke, an international law firm specialising in employment law and contingent workforce. Our keynote speakers for today are firstly Thierry Vierin. Thierry has more than 30 years of experience in the staffing sector. He's an employment specialist with a specific focus on workers' misclassification, the leasing of employees, and contingent workforce in general. We're also joined today by, welcome Thierry, we're also joined today by Johan Collard, Senior Associate who works in Thierry's employment team in Brussels. Johan regularly advises and assists staffing and workforce solutions companies, including platforms that operate within Belgium on a wide range of different matters. And welcome to you, Johan.
Thank you.
From Giant, we have Charles Dorr, a familiar face, who Sales Director for Giant Global, helps clients access talent globally and compliantly using Giant's range of international payroll services. Clients include UK recruitment businesses as well as end hirers that are based overseas and who hire globally. Good afternoon, Charles.
Hi, everyone.
My name's Dan Haslam. I'm Chief Business Development Officer here at Giant, and I'll make sure I weave through the topics today and be the host for today's webinar. So what we'll do is we'll pop the questions across to the three speakers. They'll go through the questions to steer us through the topics that we'd like to cover, to try and give insight into the considerations for businesses when you're hiring workers in Belgium, and also try and tease out some practical ways that you can mitigate some of those associated risks. So let's kick off then and begin by looking at Belgium's approach to labour leasing. Jokan, if I can start with you, please can you briefly explain what you mean by labour leasing?
Well, thanks, Dan, and hello everyone from Brussels. It's great to be here to set the scene for today's Belgium session. As many of you will know, Belgium punches well above its weight because of its location at the heart of Europe. Brussels hosting the main EU institutions, Antwerp being Europe's second largest port, and a multilingual workforce, so that all feed into a very dynamic labour market. Belgium also boasts a cutting-edge, export-driven business ecosystem, especially in chemicals, life sciences, constructions, and logistics. So yes, Belgium produces much more than waffles and beer. Let's leave chocolate to the Swiss. And the demand for skilled, flexible talent remains strong in all of these sectors. To keep us honest, it's also fair to say that Belgium has one of Europe's more complex employment law frameworks, with intricate rules at both federal and regional levels, plus sector-specific collective agreement, CBA, layered on top. Add in the fact that Belgium has 3 official languages, 4 regions, and you start to see why things can get complex. Anyway, let's crack on with labour lease. In very broad terms, labour lease can cover a wide range of staffing business lines, contingent staffing services, temporary workers, EoR, MSP, agency or principal models, consultancy, umbrella, etc. However, if we narrow the definition, Belgian law, like other European jurisdiction, recognizes only 2 worker statuses, employee and self-employed. Consequently, labour leasing mainly refers to putting employees at the disposal of an end user. It is defined, let's say, as a situation in which an employer allows a third-party user to benefit from the services, the expertise of one or more of its employees, while the authority normally vested in the employer is partly exercised by the third-party user. And this mostly covers situations where an end user client, for example, gives day-to-day instruction to a worker employed by another company, or where a contractor, a consultant, a freelancer placed with the end user client ends up directing the end user's own personal owned employees. So in general, Belgium regulates labour leasing very strictly and even prohibits it in some cases. Well, we're not going to give a Belgium law lecture, of course, but let's just keep 2 key rules in mind at this point: the strict regulation of labour lease and the strict separation, the strict distinction between employee and self-employed status. That's the, let's say, underlying rules which should be kept in mind in any triangular operational model, whether that's temporary agency work, the so-called TOW, or consultancy, employers of records, MSP, and so on. So it's important to note that sanction may apply in case of non-compliant labour lease, with consequences not only for the staffing business, but also for the end client. For example, the end user could be deemed to be bound by an employment contract of open-ended term with the leased employees. The employees may, on its turn, terminate the employment agreement without having to respect any notice period or pay any indemnity in lieu. The end user and the staffing company could be held jointly held liable for the payment of the remuneration, indemnities in lieu of notice, etc., social security as well. And both the end user and the staffing company may also incur fines from employment authorities. But the good news is that Belgium legal ingenuity offers compliant, practical ways to navigate this restriction. And depending on the type of staffing model, there are a few legitimate ways to structure things that stay within the strict regulation of labor lease. I'll briefly cover three options here. First option is by obtaining a license where the activity actually requires a license. For example, temporary agency work, for example, this activity requires a license in Belgium in all 4 regions, but also potentially MSP activities or EoR, we'll see that in a minute, or also a staffing license in case of recruitment services, outplacement services, for example. In case of temporary agency workers, it should also be noted that it isn't just subject to a license, it's also limited to specific grounds, such as replacing permanent employees on a medical leave, a temporary increase in workload, or just an assignment intended as inflow as a pathway to hiring by the end user client. So the first option is the license. Second option, you may also include what we call an instruction clause in the commercial agreement between the staffing company and the end user client. The so-called Article 31 clause, because it comes from Article 31 of the Belgian Act on Temporary Work. And with this clause, the end user can give limited, clearly defined instruction to the leased employee about how the services are performed. And this clause should set out precisely what kind of instruction can be given, also that such instruction do not prejudice the authority of the employer and the user actual performance of the contract. The fact that the contract corresponds to what has been agreed in writing between the parties. This instruction clause is an important tool in the staffing sector in Belgium. It's a kind of wild card that allows you to organize staffing activities without drifting into areas that require a license. And that's also why it's so essential to draft it carefully. So the second option is this instruction clause. And lastly, and this is more kind of a niche route, a third option exists in the construction sector. Under a strict conditions, an employee lease can be allowed for a limited period of up to 3 months between 2 construction companies. So these are, broadly speaking, the 3 options in case of labor lease.
Great, thanks, Johan. Interesting, because there's certainly some specific options there that you don't necessarily see within other countries. So that is interesting. What would you say were the key advantages and risks then for companies when they're opting to lease workers in Belgium instead of sort of directly hiring them?
Well, the key advantages are many and depend on the sector and the business lines. Top of the list are easier access to specialist expertise, greater flexibility, the ability to work on a project basis, to organize remote work for EoR, lighter admin load for the end clients, and the lower risk of creating a permanent establishment for tax purposes, which is also an important aspect. The risks are fewer, but still worth keeping an eye on. There is the risk of prohibited labor lease, as we just mentioned it, potential liability for the staffing company if the worker underperforms, depending on the clause in the commercial contract with the client, misclassification risk when working with freelancer contractors, and the fact that some protective clauses like non-compete, non-solicitation may not be enforceable in some cases.
Okay, so really it's the access to that, like we said at the beginning, the flexible talent pools and the different types of workers that companies want to bring in to get the work done, which makes sense. So how do Belgian labour laws affect the leasing of workers in terms of job security and benefits and worker protections? Can you sort of give us a bit of an outline there?
Well, sure, that's a good question, because several of the protections that apply to an end user's own employees, own personnel, could also extend to leased employees. And this includes health and safety instruction, of course, but also protection against discrimination in all its forms, working time limits for employees, protection against personal liability, except in very limited cases. Also, if a leased employee is later hired by the end user client, the prior service can count for seniority. Regarding remuneration, temporary agency worker, for example, may not be paid less that she or he would have earned if hired on the same terms as a permanent employee of the client. In case of employee lease, the end user clients must also promptly inform its employee representative body, the Works Council, if there is one, that an instruction clause is in place, and the client must also provide this representative body who ask it with a copy of the commercial agreement and the instruction clause for the employee lease.
Okay, so definitely talking through some of those points, things like the agency worker regulations around making sure that someone who's working on a leased basis is having the same benefits in line with a permanent worker sound like a familiar concept. Are there any industry-specific regulations or best practices that companies should be aware of when they're thinking about leasing workers in Belgium?
Well, yes, indeed. Aside from the two rules we mentioned above briefly, so the strict regulation of labor leasing and the risk of misclassification, stricter rules could also apply in certain sectors. And for example, in the construction and industrial sector, chemicals, engineering. In construction, for example, the labor authority inspection are more frequent as the sector is more exposed to misclassification, illegal cross-border posting of workers and workplace accidents, unfortunately. So for example, depending on whether a worker is comes from abroad, is foreign or seconded in Belgium, the employer must still comply with a minimum set of Belgian, let's call them public order rules, such as the sectoral pay scales, bonuses and benefits, working time limits, rules on leaves, and so on. The employer also has to meet certain sector-specific formalities on the construction site, including listing subcontractors, checking at work, specific badging obligation like the Constr badge, safety training, etc. In the chemicals, industrial work sector, engineering, end user clients also often require the staffing company to hold a so-called VCU certification. So VCA is a kind of safety certification which is valid in the Benelux for companies active in higher risk sectors, construction again, chemicals. It's not a legal requirement like a license, but it's widely treated as such as a kind of industry standard. And this certification system could require VCR certified companies to work only with VCA, VCU certified subcontractors provider. VCU, because we use both VCA and VCU. VCU is similar to VCA, but it's more aimed at staffing companies that supply or post temporary workers to work sites, projects in such higher risk sectors. It only applies where day-to-day authority over the employees is transferred to the end user, typically for tow workers. So both this certification could be obtained after specific training for the relevant employees and an audit by a certification body.
Okay, thanks, Johan. Yeah, I think it's good to understand at a national level, there's obviously got to be compliance with employment and tax law, but equally when you start looking at specific vertical sectors, there could be other requirements that businesses need to be aware on. So that's really useful. Thierry, it'd be great to bring you in here and move on to our next topic. And a quick reminder to the audience, if you do have specific questions in your business relation to Belgium, then please do pop them in the Q&A and we'll come to those at the end. So Thierry, can you talk us through now licensing rules for employer of records in Belgium? Pretty interested in what the Belgian government's approach to EoRs is and how this has evolved over the last few years, and what do you think the key takeaways should be for businesses that want to use employer of records services?
Yes, thank you, Dan. So employers of records are more and more popular in Belgium. I would say we see them more and more. It's an easy solution when you want to start a business in a country, typically. They operate a bit in a gray zone today. There is no specific legislation in Belgium concerning EoRs. There is no clear legal framework. We have a new government. It's not that new. We have a government since 12 months, a right-wing government, and we also think they will not take initiatives with a new piece of legislation concerning EoRs. So until 29, normally the framework will not evolve that much. Today, typically EoRs have two options to operate, and Johan touched upon it. Or it's the TOW model, temporary agency workers model, with then the specific license of a temporary work agency. Or you have the option of the instruction clause that Johan explained. In an instruction clause system, you need to have in the commercial agreement between the provider and the end user the limited operational instructions that the end user can give to the employees of the provider. So these are the two models today if you want to operate according to the legal framework. Since beginning of the year, there was kind of surprise coming from the Flemish authorities. So, you know, in Belgium, we have three main regions, the Flanders, Brussels in the middle, and then Wallonia, French-speaking part. And so the Flemish authorities have said, and it's still on their website, quite short, but it's on their website, to say that if you are an employer of record in operating in the Flanders, so if your clients are in the Flanders, that you would need a TOW license. So that was a bit of a surprise, so to say, with then also Federgon, the Federation of the Temporary Agency Workers, commenting on it, the different authors commenting on it. And it still remains a bit unclear if you just need a license or if you also need them to comply with all the complex legislation that Johan was referring to. It's a kind of tripartite agreement with the user and the temporary agency worker. The fact that it's limited to specific situations of increase of work at the end user, etc. The fact that you have to pay to your temporary agency worker the same salary as the person that he or she replaces at the end user, etc. We are of the opinion that you could, as an employer of record, continue with the instruction clause model, which is more flexible, so to say. But it will probably depend a bit on your business model and the type of workers used by your client. If it's more blue-collar workers, typically, then a TOW model would probably make sense. If we are talking about high-skilled consultants, we are of the opinion that an instruction clause model could remain applicable and used as an employer of record. So we will see in the coming months how this evolves. There is no regulation really on that. What the Flemish authorities have said is what we know already, is that putting at disposal of people is forbidden in Belgium. One of the exceptions is the TOW regulation, so that is not new. But what is new is that they say that employees of record need to have that license. In Brussels and Wallonia, for the time being, there was no such recommendation. But so that's a bit the framework then as it is today.
Okay, great. And building on top of that then, what additional compliance or reporting requirements do employer of records face in Belgium compared to other countries, Thierry?
Other obligation is a reporting obligation indeed. If you have a license, a tow license, you will have to do an annual reporting of your activity. The same is true, by the way, if you have a license in Brussels or the Walloon region for permanent staffing, where you typically have to complete an annual report telling how many people you placed, in what sector you are active. And in general, as for the tows, this is kind of information that the public authorities use for statistics. Typically, they want you to do their job, so to say, but by giving them information, they are able to build statistics around the tows and permanent staffing for that other license. Yeah.
Okay, and just interesting there then, obviously this tour license, temporary agency work license, obviously if we looked at Charles's world from an employer of record perspective, he doesn't do recruitment as such. He's obviously just employing people. So does the tour license, can it only be applied to businesses who are actually doing recruitment services, or is it just anyone who is employing a worker who's not the end client, basically?
So the tow license will yes be necessary if you are in the tow model, of course. But so as an employer of record, yeah, you would need the license as well, according to the Flemish authorities. Yeah.
Okay, so that makes sense then. So it's just the key is the fact you're being the employer of record as opposed to the fact you're just doing a recruitment service. It applies across both. That makes sense.
Yeah, indeed. Yeah.
Any specific penalties then or risks for employer of records that don't get the rules right and don't follow these licensing rules in the regions?
Well, the risks are twofold, so to say. So a first risk is that if you don't comply with the rules, is that potentially workers could claim to have a contract of employment with the end user. So that's, you could say, more a risk, not for you, but for the end user. But the risk is also for you because that will put your relationship with your end user at risk. And your commercial agreement will certainly contain clauses where you have to guarantee your end user in case of risk or of reclassification or misclassification. So you will indirectly also bear that risk or liability. There is, of course, a risk of fines, administrative fines, potentially criminal fines, even if that is a bit more theoretical. Often the inspection, social inspection, will give you some time to be compliant and will typically come back after a couple of months to see if you have done the necessary work. Okay.
Yeah, good. Important then to get things right, as you say. It doesn't take much noise to destroy a relationship between a business. So taking legal advice before you enter these arrangements is no doubt a good recommendation. So thank you, Thierry. Okay, so we'll move on to our next topic. And again, a reminder, if anyone has any questions, please pop them in the Q&A section. I can see we're getting a couple coming through. Worker misclassification, always a hot topic, no matter which country we're focusing on. And certainly in the UK, it seems we've been discussing this topic, or commonly referred to as IR35, for many, many years now. But of course, it's not a new concept. Every country has a similar approach. So I'm fascinated to hear from Johan on the rules around how workers can be engaged and operated in Belgium. And it'd be interesting if you can just talk us through the Belgium approach to the concept of worker misclassification.
Well, in Belgium, things are very, let's say, pretty straightforward on this point, at least on the surface. Either someone is hired under an employment contract and works under the employer's authority, or she or he is self-employed and collaborate under a service contract. However, as Belgian employment law is kind of strongly protective towards employees, because both employers and employees pay substantial social security contributions sometimes, misclassification claims can be brought either by the self-employed individual claiming to be an employee and seeking the protection and indemnities offered by employee status, or by the social security authorities. And in case of litigation, in order to tell the difference between being an employee and being self-employed, a judge usually looks at four main criteria. What the parties intended to do, what the contract says and how it works in practice, whether the person can set their own working hours, decide on the working time, etc., whether they can organize the work themselves, and whether they are working under subordination, hierarchical control. So subordination is a key feature of an employment contract. And if these factors point to authority and control, a judge can, let's say, easily reclassify a self-employed arrangement as an employment contract. And also in some sectors, including platform work, but also construction, security, there is also a rebuttable presumption which apply on top of these general criteria. And as a rule, let's say the greater the degree of control and risk on the company side, the less likely it will be a self-employed relationship, a consultancy, for example, agreement. No one factor is conclusive, but the overriding principle is to look at the reality of the situation and not only to label the parties and not only to the label, to the name the parties have given to the contract.
Yeah, well, again, it's clear to see control is a big factor, which I think we're all familiar with. You know, how much control is exerted on the worker is usually indicative of self-employment or not, as the case may be. So that's interesting. And what are the consequences for businesses in Belgium then if a worker is misclassified, Johan? Are there any particular penalties that are brought to bear, and what's the enforcement activity look like?
Yes, unfortunately, in case of reclassification of the self-employment as an employment contract, the employment contract will in principle be considered as having been concluded for open-ended term on a full-time basis. And as a result, the self-employed person, the contractor, may bring a claim against the company, the staffing company, for example, or the end user client, which would include salary arrears, indemnity in lieu of notice, possible damages, and moreover, the company, the so-called employer in this case, should be liable for the payment of social security contribution on behalf of the self-employed person from the start of the occupation, and that amounts to more or less 40% of the gross monthly remuneration invoiced by the contractor after VAT, etc. So quite a substantial amount indeed.
Yeah, significant amount. So something that people need to pay close attention to, clearly. Any specific examples or case studies that you've seen in Belgium that would indicate some lessons to be learned here?
Well, it didn't ended up in the court, but I'm thinking of a specific case in the construction sector, which, as I mentioned earlier, is often targeted by investigations and inspection. And it involved one of our clients on a major construction site in Belgium. Labor inspection came on the site and decided that the subcontractors' personnel, so not our client's own staff, but the subcontractors' workers, which were foreign self-employed personnel, were not truly self-employed, but employees. We were talking several dozen workers here, and the inspection immediately halted the subcontractors' activities in Belgium. We managed to resolve the matter by negotiating a settlement directly with the labor authorities, which involved the payment of an indemnity. More recently, there have been reclassification decisions in the platform sector, which often relies also on independent self-employed couriers, for example, or drivers. and these cases have drawn significant media attention. So the key lesson, so to say, is to review the contract and exactly how the tasks will be performed before the work starts actually. So you can secure the working relationship with clear, tailored, fine-tuned safeguards.
Okay, good. And any particular steps that you'd advise companies then to take to ensure that they are getting that classification piece correct over and above reviewing the contract?
Well, it's a bit difficult to speak generally on this, but these steps need to be fine-tuned to each business line and business model. We usually recommend a well-drafted contract that both parties genuinely understand, and that's been reviewed by a lawyer, ideally, plus a checklist to assess the risk of full self-employment. Also to minimize any signs, any hints of authority, like direct instructions, disciplinary measures, or employee type benefits, such as bonuses, etc. In general, freelancer or contractor operating through its own ManCo, management company, is also less exposed to this risk. And in certain cases, a prior ruling on the employment relationship could also be requested from the labor authorities.
Okay, great. No, thanks, Johan. I think there's definitely some good takeaways there for the audience. Charles, it'd be great to bring you in here, if I may, please. It'd be good if you could just give us an overview then of how workers can be engaged and the different types of suppliers that can provide these workers if businesses are looking at Belgium as a place for talent.
Yeah, for sure. So it's probably useful just to outline to the audience the type of providers and solutions in the market that provide EoR and AoR services like Giant do, and how they can help to engage workers. So an EoR service, as we've talked about, is an employed option. The worker will have an employment contract. It could be open-ended, it might be fixed term, but each month there'll be a payroll run, and the worker would receive a net pay along with the pay slip. So all taxes would be deducted at source, all employer costs would be paid direct to the local authorities, and the worker is able to really focus on the work while all of the admin associated with being paid is kind of taken care of for them. Now, the AoR service is where the worker is operating as self-employed, or perhaps through a limited company. And with this solution, the worker would receive a gross payment, and it would be part of their responsibilities to pay their taxes and social securities directly to the authorities themselves. There are other forms of engagement, but really EoR and AoR is what we use as a catch-all to really kind of gather up the main types, and I think has been said already in the webinar today. Really, within Belgium, you do have employment or self-employment, and those are the two kind of definitions.
Yeah, good. It's nice. It's clear, or clearer certainly than the three types that we have of tax, employment, and worker and self-employed that we have in the UK. So maybe we could take a leaf out of the Belgian book there for sure. Thierry, it'd be good to then come back to you and hear your views on these different worker engagement types and what people should be thinking about when looking at engaging workers in these different ways.
Yes, thank you, Dan. And to add to what Charles said, so in Belgium, contractors are very common, and Johan explained the reason. The main reason is the high social security charges for employees and employers. We are talking about 40%, 13 to be paid by the employee and 27 more or less by the employer. It is even so that some high-skilled people, higher management will not accept to be engaged in general under an employment agreement anymore, and even in large consultancy businesses. They want to keep their management company that they have set up, they want to be able to optimize from a tax perspective the remuneration they receive. And so it becomes challenging when you hire people earning more than 200K, for example, to say, step in as an employee. No, they will in general refuse and say, I want to work as a service provider. That's where the AoR can come in. So this is a model that we see indeed in Belgium, where you will, as an end user, decrease the risk of misclassification because your contractors are managed by an agency of records. Concerning contractors, our advice would also be to try to use them via their management company, because like Johan said, it decreases the risk when you have the management company in place, and they are very common in Belgium and very easy to set up in a couple of weeks, so to say. And then on the employer of record model, well, we talked about it. Perhaps just to flag the PE risk, the permanent establishment risk that Johan has touched upon. People sometimes think that you will not have that permanent establishment risk by working with an employer of record. This is not true. It can decrease the risk, but it will mainly depend on the job roles of the people that you have working in Belgium. If these people can engage your company, can sign contracts, for example, there the risk would be higher than if they are more in an administrative function.
Okay, good. That makes sense, and that ties in well as well with what obviously Charles was saying there in his section. So thanks Thierry. So I think now let's move on to our next topic, which is the EU Platform Directive. I'm probably just conscious of time. I'm going to shorten this down a little, but Johan, it'd be good if you could just give us a bit of a talk through the EU Platform Directive and its impact, particularly on the classification of workers in Belgium, and then what that means for companies using platform workers, and then we'll look to move on to the final topics.
Sure, that's indeed a hot topic, and I won't be too long on this, but to give a bit of context, this new directive is the first attempt at regulating the gig economy. One of this directive main goal is to set a minimum rules to help properly determine the employment status, and also by introducing a presumption of an employment contract. This directive settles a few definitions, among which platform, of course, and platform workers, which are defined broadly enough that they could potentially catch staffing companies if they use algorithm to organize or control work, from the selection, matching to the allocation of assignments, via an app or a portal or an automated performance monitoring, algorithmic decision, and so on. So potentially staffing company EoR could fall into the scope of this directive. Belgium already introduced its own set of platform rules since 2023. Just after the COVID period, including a presumption of an employment contract and also requirement for platforms to take out work accident insurance, also for self-employed workers, and this would be applicable as from January 2026, so in a couple of weeks. We also know that investigation from the employment authorities are already carried out in the field, so it's important to check first whether the business could potentially fall within the scope of these directive provisions.
Yeah, no, it's an interesting topic because we know, the use of these platforms to find work for people across Europe is huge. So it's interesting that Belgium are sort of really taking a lead on this. And I think you make an important point that sometimes it's not quite obvious whether or not a company is a platform or not, but certainly with the use of AI going into many recruitment agencies, then you can well see that there could be an argument to say they're stepping over into more of a platform type model. So that's interesting. So let's move on then away from the EU Platform Directive onto the next topic, which is back to you, Charles, around looking at the different types of temporary workers. So if you could just briefly walk us through the different ways that workers can be engaged in Belgium, that would be useful, I think.
Yeah, for sure. I guess ultimately, if a company wants to engage a temporary worker, there are three options to them. They could do direct employment, so either a permanent or a fixed term contract through the company's own Belgium entity. There's the EoR model that we've been talking about, where a licensed Belgium employer of record is the partner who hires the worker and seconds them compliantly. Or you have the independent contractor. So via a valid self-employment setup, the AoR model, providing there is, I guess, genuine independence and no subordination involved from what we've been discussing.
Yeah, no, I think that's really, really clear. So then we're left with our last topic before we drop into the Q&A. So please do, excuse me, submit those questions. We're going to be coming around to them shortly. And so the last topic we said was considerations for UK recruitment agencies who are thinking of setting up in Belgium. So Charles, if I can stay with you, what would you suggest or recommend to your UK agency clients to be the first steps if they are thinking about expanding into Belgium?
Yeah, so I think thinking about key considerations, understanding the regulatory environment is absolutely key. I think as we've kind of mentioned today, Belgium's employment market is governed by strict labour laws, and there are sort of sector level collective labour agreements. And so before expanding, I think a UK agency really needs to decide how it plans to operate. Will they be placing contractors, so going for that AoR model, or will they be employing workers on behalf of their clients, the EoR model? And as we've talked about, each route has distinct compliance requirements. Obviously, the licensing requirement that we've talked about with EoR. And so if you do intend to supply temporary workers to client companies, you're going to need to hold that temporary work license. Alternatively, you can just look to work with a partner. So an EoR provider in Belgium who can legally employ the worker on your behalf. That may then mean that you don't need to have the license potentially. I think the recommended entry strategies, let's call them, that we've talked with some of our clients around is, if it is short term, then partnering with a Belgium EoR is very much the way to go. Gives you access very quickly and easily without perhaps having to do all of the legwork yourself. If you are looking at more of a medium-term engagement, then building a Belgian client base and a contractor pool that could then move you into perhaps a bit of a hybrid role where maybe you do have your own entity, but you still utilize an EoR for the employment piece. But then maybe the long-term consideration is setting up your own company, holding a license and running your own payroll internally, perhaps once volumes justify it. So it really depends on what your end game is. Is it a short-term project that actually you don't need to kind of completely get into bed with the Belgium system for, or it actually is it a long-term play where in time it would make sense to kind of put all the correct establishments in place?
Yeah, no, that makes sense. I think it can be an expensive exercise, obviously, to set up a permanent setup. So using an EoR, at least to get confident that there's a demand is there to support a more permanent setup, so would seem to be a logical piece of advice. Thanks, Charles. Thierry, it'd be good if I can just bring you in then, please, if there's anything else that you would add in terms of the points Charles has made, or specific cultural or operational differences that you see between UK and Belgium businesses that agencies should consider.
Yes, then differences or yes, recommendations or three takeaways. First, perhaps, is that the use of contractors and management company in Belgium is absolutely possible, and it remains important. Two, we see more and more that large clients will require a license from their provider, and even if you will not provide temporary agency workers, it's the license can somehow give you some weight in the market. And then 3, something to decide when you set up in Belgium, that is potentially to split your business in 2 entities, one for the tows, if you have tows, and one for contractors, permanent staffing, typically. Even if you could do everything in the same legal entity, sometimes it makes it easier to have 2 entities set up, one for the tow and one for the remaining business you are doing in Belgium.
Yeah, no, I think that's good advice. Often when you move into that space, you're not really necessarily going to know if you're just going to be moving down one road or the other. So have both options covered to make sure that you're being as commercially open as possible. Very good. And then just lastly, Thierry, if we can finish with you, and then we'll move on to the questions. Any final advice that you'd give to a UK recruitment agency thinking about moving into the Belgian market? What would you say to them?
Well, then we talked about the complex employment system in Belgium. When I compare to other countries, I think we are still in a quite liberal system, quite close to the UK in a lot of aspects. And so it's certainly worth exploring the Belgian markets. It's quite easy to do business, and we are less regulated than countries like Germany, for example, in terms of contingent workforces, contractors, etc. So it's certainly worth exploring.
So there you go, guys. You heard it loud and clear. Belgium is open for business, and you shouldn't be scared. And hopefully today's session's given you a little bit more comfort around those topics. So thank you to all the speakers for that. Let's now get stuck into some questions. So we have a few, and it's nice to see a number of people on the call from lots of different European countries. So first question here from Lucas. Is it possible then for an international organization to hire across one team, both regular employees and contingent workers? So a general question, is it possible for a company to hire both types of workers on a project? Thierry, maybe if you want to give us a view there.
Yeah. Well, it is possible, but what you have to avoid in general is to have the same jobs exercised by employees and self-employed in the same team, because that could give ideas to the self-employed to consider themselves as employees. So we see that quite often. But yeah, caution is certainly required, or if people have different jobs, different works to do, then there is no issue. If people are doing the same in the same team, then it's a bit more risky to have self-employed people together with employees.
Yeah, and certainly not unusual for there to be different types of workers being deployed on a project because there'll be different roles. So that makes sense. Good. A question from Christopher. Hello, my business holds the license for temporary work in Luxembourg. Therefore, I understand that we would not need to gain a new authorization for Belgium, but would only need to comply with the Belgium employment legislation, reporting, etc. So question mark for his statement at the end there. He's already got the license for Luxembourg, but he understands he would not need to gain a new authorization for Belgium, but would only need to comply with the regulation reporting. Johan or Thierry, have you got a view?
I can answer quickly. Unfortunately, license is really linked to the region where the activities are performed. And in Belgium, as we say, there are different regions. So if the company operates, even though it holds a license from Luxembourg, Belgium being a different jurisdiction, the company would need to apply, for example, for tow activities for a license in the region where it operates, whether it would be Flanders or Brussels. We briefly talked about VCA, VCU certification in the construction and engineering. Those certifications are valid in the Benelux in general, so also in Luxembourg and in the Netherlands. But when it comes to staffing license, it's a very regionally based license, so they need to apply, unfortunately, in Belgium to the competent region, indeed.
Well, please, Christopher, that you raised that question. Then there's obviously some work to be done if you are operating in Belgium. I'm sure that Johan and Thierry would be happy to pick up that conversation offline. We'll move on then to one of the final questions. So one from Catherine. Hello, Catherine. Under agent of record, is there any risk to the agency if the worker doesn't pay the relevant taxes? Any views there, Charles?
Yes.
Do you want to come in on that?
Yeah, sure, can do. I guess ultimately the risk isn't necessarily to the agency in reality, because if we've got a standard contract chain of an end client through to a recruitment agency, maybe through to a company like Giant who acts as an agent of record, and then you have the worker. If that worker hasn't paid their taxes correctly and properly, I guess the authorities firstly would go to the worker to say you haven't done what you were meant to do. But then ultimately, then I guess they're more likely to go to the end client and say this individual didn't pay their taxes correctly. They were working for you. It was your responsibility. So I think although we would all be within a contract chain and it would certainly cause problems for relationships, like we touched on earlier, I imagine it's the end client who would probably be in the crosshairs of the tax authorities if something didn't happen correctly with that worker. So for the agency, I don't think the Belgium authorities, for example, would be coming knocking on the door of a UK-based recruitment agency for unpaid taxes of a worker, but they would come knocking on the door of the Belgium end client. And so that's really the bigger risk for the agency is perhaps blowing up that client relationship and causing a problem for their client.
Yeah, very good. Thierry, do you have anything to add there or agree with Charles?
Yes, I agree with Charles, except if there is really a fraudulent system put in place, they could then potentially go against everyone, but that is not what will happen here. No, we don't have really a cascade system like I think you have in the Netherlands, for example. And what Charles says about the end user, yes, but then again, the administration would have to prove that there is a kind of employment relationship that took place, that there is a kind of misclassification. But so no, the risk I don't see the risk for the AoR indeed. Yeah.
I think as soon as you see or hear the acronym AoR, then immediately the biggest risk you jump to is, well, is that the correct classification? And then all things feed off the classification decision and how robust that has been. Gentlemen, I really, really appreciate your time and joining us today. I think that was super useful. Loads of thanks coming through from the audience. So thank you to Thierry, Johan and Charles for joining us today. We will make sure we follow up with the recording to everyone who registered. We'll make sure that contact details for all the speakers are on that follow-up. So if you do have further conversations, then please feel free to get in touch, and I'm sure the chaps would happily support that. Thank you, everyone, for taking the time to join us, and look out for the next webinar. And it just remains for me to wish you all a great afternoon and enjoy the rest of the week.
Bye, everyone.
Thank you.
Thank you.
Bye.
Bye.